Good afternoon, Dr. Shankar.
Good afternoon, Dr. Prakash. Very nice, very pleased, happy to meet you. Yeah.
Thank you, sir. Thank you. And good afternoon, Mr. Nitin.
Okay.
Good afternoon, Navin sir.
Good afternoon, Doctor. Good afternoon, Dr. Tapas. Welcome, Dr. Vijay Shankarji, V. Shankarji,
Thank you.
for this particular session of expert lecture series.
We'll wait another 5 minutes. People are joining. So then we will start today's program with a brief inaugural session, followed by the lectures with the two experts today we have. So we'll start with two lectures. Naveen sir, shall we start?
We can, sure, Dr. Tabas, we can start. Definitely, we should start on time.
Yes. Actually, we need to finish on time also. So
Yeah.
I think people are still joining, but I think we should start. So, Diksha and Harshita, uh, please start. Okay.
Sure, sir. Creativity. Creativity is thinking up new things. Invention is doing new things.
Good afternoon, everyone. I'm Diksha Suri.
And I, Harshita Bhatia,
Would like to welcome you all to the Impact Lecture Series 2022-23, sponsored by the Ministry of Education's Innovation Council and All India Council for Technical Education, Government of India, and organized by Institutions Innovation Council, National Institute of Technology, Hamirpur.
today we all are here to ornament our knowledge with the experiences and wisdom shared by our esteemed speakers. Dr. Hari Mohan Pillai, Professor, MIT School of Architecture, MIT AGT University, Pune. Dr. Sunil Dhole, Director, Techno-Orbital Advanced Materials Private Limited, Kanpur, and co-founder, Chemdist Membrane Systems, Pune. Dr. V. Shankar, founder at Deep Tech IP, Coimbatore, and Mr. Nitin Saurabh, Head, Technology Transfer Group, SRF Limited, Gurugram, Haryana.
Let us dive into this infinite pool of opportunities that the innovation and startup world has to offer. I would like to introduce you all to Dr. Tapas Palai, convener of Institutions Innovation Council, NIT Hamirpur, and coordinator of Impact Lecture Series. Dr. Tapas Palai is currently serving as an assistant professor in the Department of Chemical Engineering, NIT Hamirpur, with more than 7 years of teaching and research experience. His research interests include biochemical and bioprocess engineering, enzyme kinetics, smart polymers, and membrane separation. Sir, we would like you to kindly brief us about IIC and the Impact Lecture Series.
Well, thanks, Diksha and Harshita. Good afternoon, one and all present here. Professor H.M. Suryavanshi, Honorable Director, NIT Hamirpur. Dr. Yogesh Gupta, Registrar, NIT Hamirpur. Dr. Naveen Chauhan, Dean, Research and Consultancy, and President of Institutions Innovation Council. All the experts, Dr. V. Shankar, Dr. Hari Mohan Pillai, Dr. Sunil Dhole, and Mr. Nitin Saurabh. All the deans, all the head of the various departments and centers of NIT Hamirpur, all the participants, students, staff members, all my dear colleagues, ladies and gentlemen. On behalf of Institutions Innovation Council, NIT Hamirpur, and on my personal behalf, I extend a warm welcome to all of you for this inaugural session of Impact Lecture Series, which is sponsored by Ministry of Education's Innovation Council and All India Council for Technical Education's Government of India. The Institutions Innovation Council, IIC, NIT Hamirpur, it was established in the year 2018 and 18-19 as per the guidelines of the Ministry of Education. The focus of IIC is to systematically foster the culture of innovation and startup ecosystem in the educational institutes. The primary role of innovation, primary role of this IIC is to engage the faculty, students, staff of NIT Hamirpur in various innovation, entrepreneurship related activities such as ideation, problem solving, proof of concept development, design thinking, IPR related activities, project handling, and management at pre-incubation and incubation stage, and several others, so that the innovation and entrepreneurship ecosystem gets established and stabilized in the institute. Ministry of Education has taken several such initiatives in this regard to promote entrepreneurship and startup activities in the higher educational institutes. During last 3 years, IIC NIT Hamirpur has taken several such initiatives and conducted several activities like workshops, hands-on training session, awareness program on intellectual property rights, several expert lectures, and several success stories, and formulation of IIC policies for the NIT Hamirpur, and there are several others. This event, which is supported by AICTE, is one such initiative to motivate young minds towards such activities. As quoted by Thomas Edison, the inventor of light bulb, the value of an idea lies in the using of it. So this event intends to generate awareness and skill on entrepreneurship, research and development, and innovation, IPR, startup among students and faculties. The objective of this event is to sensitize and motivate students and faculties to pursue innovation and startup during their academic, to generate awareness on innovation, IPR, startup among the students and faculties, to establish strong connection with ecosystem enables at regional and national levels, and aware the students and faculty members about the innovation and startup ecosystems. Keeping this in mind, this program has been planned to conduct. During this program, there will be 4 expert lecture sessions on IPR, on role of creative design for commercialization, entrepreneurship, and technology transfer. So in this particular program, we will cover these 4 aspects of innovation and IPR related activities. The two such expert lectures will be conducted today, that is June 25th, and the remaining 2 will be on 11th of July. The eminent speakers from the various domains, as mentioned earlier, they will share their experiences, and definitely they will interact with all the participants during their expert lecture. I am sure that all the participants must be benefited by attending this session. We are happy to share that we have received participation request, huge participation request, and the program is also being telecasted on our YouTube channel, NIT Hamirpur YouTube channel. So those who are not able to join online, they can also follow the YouTube link where this program is being live telecasted. With this, I hope the session will meet the expectation of all the participants and request the participants to grab the maximum opportunity out of it. With this, I will thank all of you for joining us today. Thank you all.
Thank you, sir. I would like to welcome Dr. Naveen Chauhan, Dean, Research and Consultancy and President IIC. Sir is rendering his services as Associate Dean, Research Projects, Collaborations and Startup, and Faculty in charge of Outsourced Multitasking Services. His research interest includes mobile wireless networks with special emphasis towards mobile ad hoc networks, sensor networks, vehicular ad hoc networks, Internet of Things, Internet of Vehicles, and the security aspects. Dr. Naveen Chauhan has excellent research contributions in these areas and has published research articles in large number of journals, including SCI and Scopus Index journals. Sir has guided 5 PhD students, 30 MTech theses, and approx 60 BTech projects. Dr. Naveen Chauhan is a reviewer for various journals of national and international repute. To name a few of them, is like Elsevier Ad Hoc Networks, IEEE Access, Springer Journal of Wireless Networks, Journal of Optical Communication, and Wiley Journal of Communication Systems. I now request Dr. Naveen Chauhan to kindly say a few words.
Thank you very much. Respected Professor H.N. Suryavanshi, Director NIT Hamirpur, Registrar Dr. Yogesh Gupta ji, today's resource persons, Dr. V. Shankar and Dr. Hari Mohan Pillai, dear participants, I, Dr. Naveen Chauhan, Associate Dean, Research Collaboration and Startup. On behalf of institutions and on my personal behalf, would like to welcome you all to the inaugural ceremony of Impact Lecture Series, in which we are starting with the first session of this series today. With the expert lectures of two eminent personalities, Dr. V. Shankar, who is the founder at Deep Tech IP Coimbatore, and going to talk about the patenting of academic research work, and Dr. Hari Mohan Pillai, Professor and Design Chair at MIT School of Architecture, Pune, who is going to talk about the creative design and innovation and their commercialization. Welcome you all. On this juncture, I would like to highlight the current research consultancy patenting status at NIT Hamirpur. In the year 2021-2022, 11 number of patents have been filed by the institute. 6 faculty members of the NIT Hamirpur have been listed in the world's top 2% scientists in their respective areas, as per the report released by Stanford University. Presently, around 35 number of sponsored research projects worth rupees 30 crores and 1 international project have been awarded to NIT Hamirpur through various funding agencies like DST, CSIR, SERB, DBT, MNRE, DRDO, HIMCOSTE, and Erasmus Mundus, etc. And these projects are in the process basically. Last year, faculty and students of NIT Hamirpur have published around 537 research papers in the index journals and the conferences. As far as testing and consultancy projects are concerned, testing and consultancy projects of worth 2.6 crores have been pitched in the financial year of 2021-2022. During the academic year 2021-2022, till now, 55 numbers of research proposals have been submitted by the faculty under various funding agencies. Today, Institutions Innovation Council under the Research and Consultancy section has taken an initiative and is organizing this lecture series, in which the first session we are going through today on 25th of June 2022, and the second session is going to be held on 11th of July 2022, which basically the first session which we are going to starting with the two personalities of Dr. V. Shankar and Dr. Hari Mohan, and with these expertise, I'm sure that everybody of participants is going to be benefited by this lecture series. In the end, I would like to conclude my talk with this shloka of Saraswati Ma, like Namastasya Sharde Devi Kashmir Purvasini Bhavamaham Prarthe Nitya Vidyadanam Chadehi Me Saraswati Namastasibhum Varte Kam Rupini Vidyaram Karishyami Siddhi Bhavatu Me Sada. हे सरस्वती देवी, आपको हम सब का विनम्र प्रणाम है और जो सबकी इच्छाओं को पूरी करने वाली है। मैं और हम सब बेसिक अपना अध्ययन शुरू कर रहे हैं जिसमें हमें पूर्णता प्राप्त हो। O Goddess Saraswati, our humble prostration unto you, who are fulfiller of all our wishes, are beginning our study. Let us attain the perfection in that always. Thank you very much once again, all of the participants and the resource persons for this particular session. Thank you very much once again. Thank you all.
Thank you, sir. I now request Dr. Tapas Palai to present the vote of thanks.
Well, good afternoon, one and all present here once again. Professor Suryavanshi, our director, Honorable Director NIT Hamirpur, Registrar NIT Hamirpur, all the head of the departments of various departments and centers, all the deans, all the participants, ladies and gentlemen. It is my privilege to propose the vote of thanks, formal vote of thanks on this inaugural session. So on behalf of Institutions Innovation Council, NIT Hamirpur, and on my personal behalf, I again extend a very hearty vote of thanks to all the dignitaries present here for spending valuable time with us. We are grateful to our expert speakers, Dr. V. Shankar, Dr. Harimohan Pillai, Dr. Sunil Dhole, Mr. Nitin Saurav, for kindly accepting our invitation and providing the valuable time for this event. We are also thankful to our director, sir, for the constant motivation and inspiration and encouragement to organize these type of events. We are thankful to Professor Meenakshi Jain and Dr. Naveen Chauhan for the guidance and support towards organizing this event. I would also like to acknowledge the support of the students, especially Abhishek, Diksha, Harshita, and several others who have actively contributed towards organizing this event. I acknowledge the Ministry of Education's and AICT's financial support for this event. This is highly acknowledged. I would like to take this opportunity to place on records our hearty thanks to the entire NIT Hamirpur administration for the logistics support. Thank you very much.
Thank you, sir. I would like to thank everyone for joining us for the inauguration session. We would begin with the scheduled lectures now, and I would like to request Dr. Tapas Palai to kindly introduce our esteemed speaker, Dr. V. Shankar.
Well, it is my pleasure to introduce Dr. V. Shankar for the first expert lecture of this lecture series. Dr. V. Shankar is the founder at Deep Tech IP. This is an IP firm focusing on providing technology and strategy advice to the corporates with the objectives of an IP protection in general and patent prosecution. Deep Tech currently advises many large and leading institutions on IP protection, including Amrita Vishwa Vidyapeetham, IIT Madras, Root Industries, Precourt, and several such. Dr. Shankar has over 15 years of experience in patent search, analysis, and prosecution. Prior to starting Deep Tech IP, he was the vice president at Maxwell, leading their advisory services on patent portfolio management, patent strategy, and prosecution for Indian and overseas clients. His team also provided various other services, including defensive publications. Prior to joining Maxwell, he worked for 20 years in material science and engineering research at Indira Gandhi Center for Atomic Research, Kalpakkam, out of which at least 8 years he has been in the technology development area of welding and surface coatings. During his stint at IGCAR, he was involved in evaluation of stainless steel and nickel alloys for weldability and developing test methodology for the same. He developed aluminate coating for in-sodium support structure of PFVR steam generator, working with DMRL Hyderabad to develop the lab scale process, and later partnering with industries including L&T Mumbai to implement the coating process in actual components. He received the PhD degree in metallurgical engineering from IIT Madras, MS in material science and engineering from Oregon Graduate Institute, USA, BE in metallurgical engineering from National Institute of Technology, Trichy. He is a registered Indian patent agent with Indian Patent Office. He has DL 320 certification in basics of advanced claim and drafting of WIPO. He has published over 37 national and international journal articles, and presented an equal number of papers in international conferences. His R&D and industrial experience characterize the unique perspective that he provides to the clients in the area of IPR. With this, I would like to request Professor Sankar to come up and please share your experiences with the audiences. Thank you.
Thank you very much, Dr. Tapas, Professor Suryavanshi, Dr. Naveen Chauhan, and I'm very thankful for this esteemed institution for providing me this opportunity. Let me share my presentation right away. So this is about intellectual property. I hope you can see the presentation. Yeah, so IP, so this is how I will base my talk. Please feel free to interrupt and ask questions. Whatever, I have about 30 slides, so, and the subject being deep, I may dwell for longer, and there is enough time for questions. So please feel free to ask your questions. And so what I'm going to present is how the patenting system works and how to prepare disclosures for patenting, do's and don'ts, because you will have to give, suppose you want to patent your idea, you need to approach a service provider who will, patent attorney or patent agent who will do the service, and you need to give them a document. So how to prepare that document? So this is about that, and how inventions are actually claimed, and a little bit about patent prosecution, what it involves, and so. So IP, as you all know, refers to any property right that comes about for creations of the mind. So any inventions, literary and artistic works, and symbols, names, images, and designs. So all of these come under IP law. So IP, there are specialized laws that govern the protection and use, because each has each of these categories of IP has its own special characteristics. So there is a requirement to legislate laws very directly, pointedly directed at each of those. Of course, just like any other property, intellectual property also should not be copied, and uh, they can be sold or rented. So that those characteristics are shared with common physical property like land or vehicle. So the interesting characteristics of IP is they all share overlap between business and law. In the case of in the case of patents and trade secrets, there's a lot of overlap between with technology also. Uh, Patents are all about protecting technology, how to make sure that certain technology is not copied, and uh, it provides a basis for leasing or licensing property right or sale. If it were not for patents, it would be nearly impossible to sell any product internationally. That is why you will see that the first question any funding agency asks is whether your patent for your invention is protected by a patent. So they will ask that question. The reason they ask that is once the patent has been filed, and immediately once when you go to a funding agency, there is enough time to develop the invention and protect it in as many countries as possible so that it can reach a wider audience. Because 99% of inventions they are globally relevant, and they can lead to products and services that can reach all over the world. So patents and trade secrets are actually complementary. They are two sides of the same coin. If you take any technology that comes up as a package, so the technology will have known information and information that's newly developed, and that can be neatly packaged and published or made into a patent. There may be other bits of information that uh, do not find readily, you cannot protect them with a formal document. For instance, if somebody is working in metal casting, or say casting of aluminum, they know that porosity is a problem there, and how the porosity is controlled in casting different alloys of aluminum will be something that is followed in industry. And each industry, they may have their own small tricks that they follow to do the casting successfully without the porosity problem. So that's what we mean by trade secret. So I will be going into detail into patents in this section, of course. Uh, Trade secrets also I'll dwell a little bit because there's not enough understanding about trade secrets. In general, it's not so well known. People do not realize the importance of trade secrets, especially in relation to patents. So I'll explain what that is about. I also would like to uh, emphasize here that industrial designs can be patented. Any object, the aesthetic design of an object that is mass produced can be protected using industrial design protection. This is very important along with the patent. The patent protects technical utility, whereas the industrial design protects the physical appearance and shape and so on. Sometimes even color and other characteristics are also protected by these. Yeah. So coming to patents, you must all be aware that it is a commercial monopoly right. So this is the only case where a monopoly right is provided by a government. If the normally government will not provide, will not encourage monopolies because monopolies may not benefit the public. In this case, definitely there is benefit for the public. How? Because it encourages innovation by the public. So either industry or academic institutions or individual inventors can all invent and uh, bring to uh, bring to the market new products and new innovations. So one way to incentivize that is to uh, cover the risk. See, technology is risky. See, worldwide, there are millions of patent documents, thousands and thousands of patent documents. But you know that there are only very few very small percentage of successful products based on those all those patents. That means not even not even 1/10,000th of the number of patents that exist for inventions in the world actually results in patents. So you can see there are good reasons for it because uh, it takes a lot of effort and belief to go behind an idea and make it successful. Even uh, even a very promising technology, unless it has the backing of a very far-sighted entrepreneur, uh, it may lose out to other competitors. One example that is given by David Poole in his book How Technology Shapes Society. Uh, that's subtitle of the book, I believe. So that book says that the best technology does not always win, but uh, it has to be backed by sufficient uh, sufficient force. That is, people must support that idea and take it to the market. Once it goes to the market and people catch it, then no stopping the technology. So that's the reason why patents are given a monopoly. And the monopoly right is only for a limited period, which is 20 years. Whether the technology will go obsolete in 3 years or whether it will last for 100 years. For instance, aspirin. No, aspirin is very old drug. Patent protection for that was only for 20 years, but it's still being used. There is good reason for it because after 20 years, anybody should be able to manufacture. A certain advantage is being given to the inventor to enjoy monopoly rights and then monopoly exploitation in terms of revenue. But after the expiry of the patent rights have to go back to the public. So the public is free to use the information in the patent document and also to commercially exploit. Of course, they will not be able to say that, hey, I have this monopoly and then others should not copy. That right exists only with the original owner of the patent and only for a period of 20 years. So it's an interesting sidelight that expired patents have a lot of interesting applications, including research, R&D, and so many other things. And people will be waiting for patents to expire so that they can try out some new things using that patent. So there is a formal application process for to obtain a patent, which is published and examined for patentability and granted if found suitable. So each patent carries a number and there is a jurisdiction. Some are only applications. This PCT application is only an application. It's not a patent and it won't give patent rights except through directly through a subsequent application to any country in the world where the invention needs to be protected. So coming to trade secrets, it's very interesting. People, inventors, entrepreneurs always ask the question, how much should I put in the patent document to share with the attorney or agent? Should I tell everything or should I hide some information? Some information may be very valuable. See, companies spend good many years and effort and manpower and money to generate some inventions. And some technologies may involve a lot of information that is not previously known at all. How do you protect such ideas? See, one way is to keep it a secret. See, the patenting system benefits the inventor by providing monopoly right to the extent of what is disclosed in the patent application and claimed. So you need to disclose and then claim. But if you don't disclose, what happens? That situation is covered by trade secrets. So if the information goes out, then value will be lost. So that is a very risky situation for any industry. See, some industries, they may decide, I'll tell you one interesting case. One casting industry approached us for a new method of casting that will nicely uh, uh, provides very controlled solidification. From the far end of the casting, the solidification happens and nicely progresses till the riser. You know, this is very important, especially for very large castings, say 400 kg, 500 kg upwards to tons. So those castings, it's very difficult to control the solidification. So people use hot topping and all that. This company had come up with a very nice design for that riser. You know that they have done some analysis and then developed a nice design. We analyzed their invention. We wrote up a patent application. Ultimately, the company said, "Oh, we don't want to file the patent." So even that situation can happen. You know, they would like to keep it a trade secret because whatever product they produce, they internally use, and they won't tell. Nobody can easily find out how they actually produce that product, that casting, and also nobody would know how much effort that how much value that invention carries. So they will keep the value also as a trade secret. But in other cases, it may be easy to reverse engineer. For instance, even the mobile iPhone was reverse engineered. So many of you may be knowing when the iPhone first came out in 2008, it was cut open. They physically cut open the phone in multiple sections. Found out, they opened it, completely disassembled the phone. They cut open, did all kinds of things. Of course, for a patent uh, professional, you don't have to physically cut open. You can actually see what all patented products are there in any product, in any marketing. I mean, product that's in the market by looking at the patents that cover the product. So that information will be very much there in the handbook or the advertising material that the company shares with the public. When you look at that, they will mention the patent numbers. You can look up those patent numbers and come to know what all technologies are covered. In the case of the iPhone, certainly the capacitive touch screen was a very valuable thing there at that time, and of course the functional advantages of the iPhone are very well known. So, but Samsung copied the um, capacitive touchscreen technology from iPhone, from Apple, and they were able to use it in their phones. They did have to face litigation from Apple, and they had to uh, settle some amount for use of that technology with Apple through a court-mediated litigation. So, but the trade secrets have no special protection. If you put some information in a patent document, then if someone copies it and you are able to establish it, then you will be easily able to claim damages. You can take legal action against them. So that's the crux of it. So in case when your product is released, people are going to find out, then no point keeping something a trade secret. So you might as well put it in the patent and protect that part. So it is used wherever it is possible to keep the knowledge a secret. For instance, complex chemical formulations. For instance, I am aware that even perfumes and other things, the perfume artists, perfume makers, they blend certain perfumes and then make these unique scents. And they are very valuable and they are promoted by brands. See these brand names and will go to these perfumers and they will buy some perfumes. And they may get the formula from them, and that's a closely guarded secret. To get the formula from the perfumer, they may have to pay a lot of money. So, and they also uh, the protecting trade secrets is possible in such cases because you cannot put the perfume in a GC and then find out what fragrances were used to create the perfume. That's almost nearly impossible. Whatever spectroscopy, anything you do, you can't find out what actually went in and what gives a unique scent because it's a natural product and natural products are so complex, it's virtually impossible to reverse engineer. And some formulations, yeah, Coca-Cola formulation is famous as a trade secret. So the other important thing to realize about patents is, although you are in India and you may be interested in filing a patent in India, it's very important to realize that the ramifications of patents mean that we cannot ignore the international dimensions. And patents are actually facilitated for international protection via UN mediated agencies. So that agency today is the World Trade Organization, and WTO administers GATT treaty and under GATT, which is an umbrella treaty, there is this PCT, Patent Cooperation Treaty. Under Patent Cooperation Treaty, we have the Paris Convention, which is a very old 1883 treaty. It is still in force. If you want to file in one foreign country, one or two countries, you can directly file within 1 year of filing in India in any other country through the Paris Convention. On the other hand, if you have a pharmaceutical invention and you want to file, patents in 100 different countries, you can do that advantageously by the PCT, Patent Cooperation Treaty route. Similar to patents, there are other treaties for trademarks and copyrights and so on. So we'll go delve a little deeper into patents. So as I said earlier, please feel free to stop me and ask questions if you have any doubts. So we already saw that patent is a commercial monopoly granted by the state. So it's a government given right, and uh, there is a formal process. And we will see the formal process in a little while. So the patent actually is a state granted monopoly. That means you can exclude others from making, using, selling, importing, or anything to do with the invention. You can prevent others from doing it. See, that means there have to be claims and there has to be a formal application that is filed with the patent office. The application has claims and a description that support the claims. There may be drawings and there is a preamble to the patent, which will be the background, how the where the problem solved by the invention is explained, and the detailed description will explain how the claimed invention works, and the scope of the claims also are interpreted based on the description. So patents are limited to geographies. So that's a very, very important fact. So if you want protection in multiple countries, you need to apply for patents in all those countries. So there are various types of patents. As I had told earlier, uh, a utility patent can protect any process, machine, device, or composition of matter. The design patent also can be filed. A new original and ornamental design for an article of manufacture. So this also can be protected. For instance, a Parker pen or a soft drink bottle can be protected. Others cannot sell a soft drink with the same shaped bottle, and this can be prevented by. And also that spurious products are all the time a problem uh, for manufacturers and traders. So that can be minimized to some extent by protecting the design and changing the design every few years once the design protection expires. So designs also have a limited validity. About 15 years is the validity of a design patent in India. Plants, some countries allow plants to be patented. So interesting thing is, patent laws says some kinds of inventions are not patentable. Inventions already disclosed to the public. If you want to file a patent, best is first file a patent, then you publish the paper based on that. So that will be a best. That will be best to protect the invention in multiple jurisdictions. Very, very important. If you sell a product before you file a patent for it, your protection is lost. You cannot protect it anymore. Many people are not aware. Even those in business and industry, they may not sometimes be aware of this. So no public commercial release of the product should be there. There are some exceptions. Publication in an academic journal is given some immunity from the bar of publication by the Indian Patent Office. India and US permit publication up to 1 year before the filing of the patent. But it is best not to publish before filing the patent in case you have idea of filing a patent for your invention. Laws of nature, equations, abstract ideas, and all cannot be patented. I once had a professor come to me. He had a powerful solution. It was a closed form solution. He had mathematical formulations, 10 pages of it in a publication. He brought that to us, and we looked at it. But we were asking him for examples. Please give an example of your implementation of your solution. But he said, "Hey, why are you asking me that? I am giving you. You take any optimization problem. This equation, you plug it, plug your variables here, you will get the solution. Can't you patent this?" Unfortunately, the patent law considers that as an abstract idea. The reason is you cannot easily sell that as a service. You cannot sell a product or service easily with it. So they went and did some optimizations, and then they developed an optimized fuel cell. that uses this technique. They use their optimization technique to design a fuel cell, hydrogen fuel cell, and that fuel cell design could be patented. So that's how that story ended in a positive way. So inventions harmful to the public morality or good are not patentable because that may result in breaking of some other law, violation of some other law that is in force. Atomic energy related inventions are not patentable according to Section 4 of the Indian Patent Act. Human animal hybrids because that would violate ethics. Medical procedures are not patentable in India. So a way to clear blockage in a heart blood vessel or a way of treating asthma. These days, they put a catheter into the lungs and then slightly warm up the windpipe so that the asthmatic contractions do not close the airways. So this new treatment uh, has been there for the past 10 years in the West, and I think for the past 4 5 years or so, it has become common in India, especially patients having emphysema or severe asthma. They'll be greatly benefited by that because your anaphylactic reaction of closing of the airways will not be there, and the patient will be able to breathe. And the seizure of totally not being able to breathe and dying because of the asphyxiation will not happen. So, but that device can be patented in India. People may be able to sell that device to doctors and hospitals, but you cannot file a patent for it. Non-useful inventions. What is that? Can anyone tell me? So non-useful means the patent office actually is not really interested in in identifying whether an invention actually works or not. All they require is technical build-up to reasonably conclude that technology will work. In certain fields, they may ask for example data. For instance, chemistry, biology, and even in computers, computer-related inventions to some extent, because the components used in the invention may be common. The processes used may be common, but because the innovation may lie in the method, in such cases, the patent office will ask for actual proof by showing data. Run the process and then give the data. It's very, very important. Without this, no invention will be granted in chemistry and pharmaceuticals and biotech. So in biotech, if you have developed a bioorganism or an enzyme that does a certain reaction faster, it's not enough to just disclose the enzyme or the bioorganism or whatever it is. You have to also demonstrate how effective it is and then show that data. So without that, the patent claims will not be granted ultimately. In the case of this perpetual motion machine, Dr. Tapas, I don't know. There's no. I was expecting some answer from the floor for this.
Yeah, actually, no one is answering. Okay.
Yeah, perpetual motion machine. It's a scientific impossibility, right? So anything that violates known scientific laws cannot be patented. So that's what this means. Non-useful invention. So that's how they decide something is useful or non-useful. So see, if you have some surprising invention where there is apparent violation of known science, you can be sure that this objection will be raised. So what can be patented? That's a huge list. Any process, machine, article of manufacture, or combustion of matter, or improvement to any of the above. So any machine, device, any industrial process, so many things can be patented. In India, till 2005, chemical substance, biological substance, all those things were not allowed to be patented. Now, because India joined the international, that is World Trade Organization, by being signatory to the TRIPS convention, uh, we became member of so many other in international trade, fully fledged member of the International Trade Organization. We allowed new substance to chemical or biological substance, material or alloy to be patented. This is very useful. The absence of this protection was very useful for Indian drug companies to develop the pharmaceutical processes, the innovative pharmaceutical processes for various known chemicals. That was very useful for that purpose, and it developed our pharmaceutical industry. Now today, our pharmaceutical industry does not have to always copy Western drugs, so they can develop drugs on their own, and this are a contributing factor because of the farsightedness of uh, the parliamentary committee that set up in the 1950s for that purpose, and their recommendations, which were implemented in 1970. So, drafting claims involves analyzing an invention, looking at an invention, if it's a device, uh, we will see what can be claimed. As a service provider, we ask the question, what problem does the invention solve? It may solve more than one problem actually. The inventors may think that, oh, okay, there's a nice way to solve this problem, but we also have to analyze as service providers and patent attorneys. We analyze whether it solves a broader problem, a broad, even broader problem is whether it's being solved. Because some inventions really do that. What other use does the solution have? Then we search. The claims need to circumscribe the prior art. See, you cannot claim today. Can you claim a pencil? You cannot claim a pencil, right? Because pencil is all well known. What is a pencil? Pencil has. You can describe a pencil as a piece of, you know, a long, elongated piece of material that produces an impression when dragged on a piece of paper. But that alone is not definitive for a pencil, even because a pen is also covered by that definition. So you see, we add these concepts together and we come to the concept that needs to be protected. If I say that, okay, a solid material uh, that produces an impression when when applied with pressure on a piece of paper, and if and I will also add one hypothetical characteristic to it. I will say that on application of the pressure, the solid substance melts and then forms an impression. That would be something new, right? Because no known pencil today has that characteristic. It doesn't melt when you apply pressure. Of course, there are many substances that are well known to melt. When most metals will melt if you apply pressure. Uh, Ice is the only thing that you know. It may, yeah. So many substances, including ice, will melt when you apply pressure. So if you add that characteristic, then that makes the uh, invention unique. So by searching the literature, The literature may be journal articles all over the world, patent applications published anywhere, any information in any printed document that can be uh, that will be important for considering whether an invention is patentable or not. We saw earlier that already known inventions cannot be patented. So a corollary to that is even by combining it to more than one document, it should not be possible to arrive at an invention. That is called inventive step. So we do a patentability analysis in any service provider whom you engage to file patents for an institution. They are going to do this. They will get the disclosure from the inventor, and they will search for prior art. And in fact, you may yourself be doing it and analyze it for patentability. So this patentability analysis is a techno-legal analysis, whatever we do, because we apply the problem solution approach. Uh, we we consider what problem is being solved, and also uh, where are similar solutions applied, and we look at it, and if we find that the invention has unique characteristics, we may recommend filing a patent for that. If not, so if that is the case, we will ask for more information to make the patent application complete. So if it is not, if we find the enough references that are too close that the invention cannot be claimed in a patent application, then we may tell the inventors, sorry, uh, it looks like the invention is too close to some references that we have found, and we will not recommend a filing here. Recently, we came across an invention that was applying IoT sensors to a sewage treatment plant, but they could not demonstrate any unique advantage to their invention. They are saying that, oh, it does a more efficient job and all that, but their data is required. Otherwise, use of IoT sensors and IoT control of a sewage treatment plant is already known. There are some references we were able to find that disclose that. So we told the inventors that no, we cannot. We won't recommend a filing there. And in case all the information is there, then we go ahead and draft a patent application, and then go ahead and file it. And so that is how this process goes. And I have some points here to for inventors who want to give their disclosure. What should a disclosure contain? It should definitely describe the problem solved, and it should fully describe the invention, including examples and validation data. So this is where I would say, if you have a publication written up, please give that publication. Please share that publication. In fact, only more information may be required, not less. Sometimes scientists and researchers think that, okay, uh, whatever information we have received, some disclosures that are just, they did a press release or something like that. They had prepared some material for a press release. They just gave it to us. We told them that no, that will not do. We need a far more detailed document. So the detail should be to the extent of a complete description, at least as detailed as a journal publication. So you don't have to do anything special. If there's a thesis or a project report, just share that report with us. We will be able to advise you, and you can also ask a question. If you have some portion of the thesis or the report that you do not want to go into the patent application, you can tell the attorney, and you can ask you can ask questions as to whether you can hide it or whether that is needed for claiming the invention. Sometimes without that information, you will not be able to get claims granted. There have been cases where such information was not available, but was later provided to the patent examiner and the controller, and patent was granted based on an affidavit that is presented with the critical, information giving proof of working efficiency of the invention. Especially in biological inventions, it is a absolute requirement that you give the uh, at least in vivo results or and not rather in vitro results and some kind of in vitro trials have to be there. In vitro data has to be there to show the efficiency. So the other thing is, how is the invention disclosure different from a journal publication? It could be the same as a journal publication, but it must clearly outline steps of a method. In fact, what we would do is, we will ask you if you say that, okay, I used thiol chemistry to generate this ligand or something like that, we will not let it go. We will ask you, what is that thiol chemistry? Tell us, what exactly did you do? That's what we will do. And all parts required to make a device work must be told. Because if it's a device, if it's a mechanical device, everybody is going to see it. When you sell the product, it's going to go out anyway. There's absolutely no point keeping something a secret there. Even a very innovative design you might have done, but when you sell the product, it's going to go out. Everybody is going to see it. Why do you want to disclose prevent the patent attorney from seeing that information? So as much experimental information as possible must be shared. Failed experiments also may be important. You may be thinking that, oh, the experiment did not work, but the depth to which patent prosecution can go, even failed experiments can be very important. So do not neglect failed experiments. Because when you say that your invention is good and all that, one of the points of uniqueness may be that similar efforts by others have not yielded fruit. They have been a failure. One of the grounds for arguing that the patent is innovative is to say that the invention has been made to work by this special step or special gadget or special design that was used in the invention. So it's a very, very important thing. That's why I'm saying failed experiments may be important. Provide characterization of new chemical entities, synthesized compounds. Provide illustrations and figures wherever possible. Hand sketches, anything is fine. Any spectroscopy that uniquely characterizes is essential for claiming for a new chemical entity. Recently, we claimed a new chemical entity a couple of years back for IIT Palakkad. They have found a uh, uh, unique sequence-defined polymer compound. So we claimed and got a US patent for them. Indian patent also is under prosecution. Schematics are very important for claiming macromolecules, aggregates, or composite materials. We need a schematic. See, many people don't think mechanistically. If you say that, oh, I put in the ingredient A, B, and C, and it's there somehow, and it works. See, that's not sufficient. For a patent, it may be very important to establish the uniqueness. So, give schematic, how the molecule will look. All those things have to be given. How much disclose? Risk of not being able to claim and protect if not disclosed. If you hide some information, or risk of the secret being discovered by reverse engineering. Somebody may, if the technical advantage is sufficient, people may be tempted to copy your idea. So what they will do is they will simply reverse engineer. There was a case of welding electrodes for repair purposes. It used to be called Magna welding electrodes in the late 70s and early 80s. It was there. You could weld any plant, any pump casing or something, shaft and all breaks. Those components are notoriously difficult to make or source, because the plant may be bought from imported pump and all that. And if the shaft breaks, how will you fix it? So it's not an easy thing. So this welding electrode came as a boon. The secret of the welding electrode was coating in the that they used. So that welding electrode coating, they could mm, people knew that some kind of rare earth oxides are being used in that, and because of the rare earth oxides, that those rare earth oxides are being able to scavenge the impurities and result in a very good weld, even though the material is not a easy material to weld, such a thing. So we would recommend that you share all the information. But that those welding electrodes ultimately were reverse engineered. They were able to guess, and others came up with. Uh, See, the cost advantages was huge. When other materials, say even the most expensive stainless steel or nickel alloy, those days, for a kilo of the electrode, it would cost about 5,000, I mean, not 500 rupees to 1,000 rupees. But these repair electrodes were costing 30, 40,000 rupees in the 80s. I'm talking, what 30, 40 years back. It was so expensive, and the cost differential was so much. It was very tempting for others. They reverse engineered, and other companies were able to make such welding electrodes for repair purposes, where the plant people are really uh, uh, they don't care much for paying a lot of money, provided it works and they get their repair job done and get the plant into production fast. So, typical questionnaire for researchers will be: does the research describe a new method, device, or chemical or biological substance? See, sometimes research may stop with just giving feasibility that, oh, okay, this is a very nice piezoelectric material that is there. This particular piezoelectric material is very useful for this particular application. The publication may stop with that, but that's not enough for a patent. You must say in the patent, we will on your behalf, we will tell in the patent application that I am claiming a device having this piezoelectric material, new novel piezoelectric material that does this useful function. That's very important, that last final step. And we need to actually give the simple design for such an invention. Very, very important. So if that is not done, so that's where that is a kind of question that's going to come from a patent attorney when he is dealing with a researcher. Is experimental validation or theoretical computation of the if you have done that, all those things you provide. If performance data versus existing methods or devices available. See, sometimes the innovation may be in a process that produces 5% more efficiency than existing. See, 5% more efficiency may seem like a small thing, but an inventor knows that it's not small. And depending on the economic advantage, if it's something that's mass production, uh, it may be 5% may be very significant. 5% cost or time saving is not at all insignificant, because everything translates to value ultimately. That is why if performance data versus existing methods of or devices is there, it will be very, very useful. So do not attempt to draft the patent yourself. You might have read patent applications. You may think that I know how to draft this. do not waste your time, because you should you can ask the attorney or the patent agent, hey, this patent is written like this. Why haven't you done that? Why have you written it in a different way? You can ask such questions, but do not try to draft the patent yourself, because uh, it interferes with our analysis. See, what we do is uh, when we analyze the invention, we generalize it. We move from a most general form of the invention to more particular forms. The reason we do that is the most particular form of the invention may be in your disclosure. It may be sitting in your examples. That is the core of your invention. But take a little bit away, slightly broaden it. That invention may still be patentable. So we have to give chance for to claim as broadly as possible. That is the reason why the generalization of the invention must be done only by the uh, attorney. So it's best you don't do that. You simply give a draft publication, and we'll be able to do that. And certainly nothing prevents you from learning how patents are written, and if particularly if there's a patent by a famous you know company, large company that you know, they have written a patent in that area, you can read that patent and then compare the patent document. If you are getting your patent written by a service provider, a patent agent or attorney, you can definitely learn from that patent as to how exactly it should be written, and whether the attorney is doing a good job or not. So patents actually are time sensitive. So I'll change tack a little bit. So far I've covered uh, I think many of you, I hope your BTech, MTech projects or PhD projects will may be able to definitely be able to get a patent application out of that, if you really think of it this way. And I hope at least one or two maybe inspired to do that. And you also need to know how to search for patent information, how to search for information. I think maybe um, you can get some experts to talk about that also as well, if necessary, because that's a very useful skill for anybody. Uh, whether you will be familiar with searching for uh, journal articles, but so you should also be familiar with searching in patents and searching on the web in general, because the web itself, even blog articles and so many sources, public sources are there that are not covered under journal publications. They will also be extremely useful. So the timeline for a patent, this looks a bit complicated, but the crux of it is, after filing an application, the clock starts ticking for if you want to protect the invention in more than one country. That's the reason why we have some things. We have so many deadlines given here. One important thing is to know is the patent is kept secret for 18 months after the filing of a patent application. And for those 18 months, nobody knows that you have filed it. But after 18 months, it gets published. And thereafter, within 4 years of filing, we need to apply for examination. That is, we need to request examination of the invention. So unless this examination request is given, the patent may not even be examined, and it will die. It will simply be closed. So that is not a. So the examination request should be given at the earliest, at least soon after the publication. It should be given. So that's the message of this one. So there is a certain patent cycle. As you know, patents are property. So unless property is useful, uh, it's very difficult to keep it. For instance, a piece of land will definitely be useful because you can build a house in it. You can build a plant or a factory or anything. You can use it for useful purposes. You can build a shop there and sell products. So there is a certain process, invention and search to identify whether it is patentable, and drafting a patent. The invention comes to a service provider like us. Then we file a patent with the patent office. That is called prosecution. And finally, the patent may be issued, and revenue will come out of it. Of course, nobody will stop the commercialization. The commercialization can start right after the patent application is filed. So no need to wait till the patent gets issued for commercializing it. So this brings to us that definitely uh, we need to make money. The invention needs to make money. But as we saw earlier, there are thousands and millions of patent documents in the world. Not all of them succeed. So how does so there has to be somebody who is a champion. If any of your innovations at NIT Hamirpur, they hold potential, commercialization potential. So there should be some mechanism of internal review so that you can put in more efforts. Maybe give funding or some design efforts or even collaborative efforts with industry can be there. And those inventions can be taken to a higher exposure. And there are so many competitions and all that. So you will be very useful to do that for to go through a process of selecting inventions for this. You may be already having such a thing, but uh, I'm just mentioning it for the sake of completeness. The other thing, interesting thing is the invention is an abstraction. See, you have a technical solution to a technical problem. That is from your side. From our side, we look at it as an invention which is claimed. So, even to interpret, if you take a piece of land, I'll take the next slide. I'll show. Sorry, we'll skip this slide. Okay. I just wanted to give some examples. I wanted to show this. Say, even invention is property. If you have a piece of land, you know where that land comes from. It is transferred from someone, either from the government directly or from a previous owner, right? So that's the provenance. Whereas an inventor invents. If the inventor works for a institution or a company or a startup, then the inventor declares that, oh, okay, that company or the startup or the institution is my assignee. I am assigning my invention to them. I am the inventor and I am assigning the invention to them. They will also accept by saying by signing on the form. The scope of a landed property is indicated by the schedule of property. You know that you go to that land and then you can measure it. Anybody can easily measure. Nowadays, even laser measurement can give you a millimeter and a GPS measurement. So many things are there. And for transferring a piece of land, you do need to register. Whereas here, also you need to register with the patent office. Here, the claims must be technically interpreted. That's the difference. The third step, the scope of a immovable property is very easily assessed, whereas scope of patent is not so easily interpreted at all. It's very tough to do that. So I'll just give you a couple of examples. So patent prosecution involves just going through this checklist. We also do that when we do a patent liability analysis and search report. We just try to see if it's already disclosed, whether it's obvious, whether it's directed to an abstract idea, or whether such an objection can come and how to mitigate that objection by adding some components or by making some modification. We suggest all such things. Then we can so a typical patent claim looks like this. So here it is a chemical method, cemental synthesis for highly nitrogen carbon nanotubes and graphitic carbon nitride. So this is an interesting method. So you need to provide the inputs and the temperature range in which the temperature range and other conditions, inert atmosphere and all those things. Then what it actually does to the ingredients and what actually happens. The end products also have to be uh, given. So this is what the invention claims, and this patent was granted uh, recently. I mean, a year back, a year and a half. So this was another patent for a non-enzymatic glucose sensor. So this is this device actually has some electrodes with copper oxide. There is cupric oxide slurry uh, and sodium hydroxide, and with carbon and silver and so on. This is all well known. This copper oxide is very good for detecting glucose. Usually, the enzyme-based sensors are used. You know that God enzyme is there. Glucose oxidase. Um, so that is normally used in enzymatic sensors, but that has limited life. You cannot store it indefinitely, and also the certain uh, sensitivity characteristics. Here, this sensor was very good. It was good to from point one to I mean, the very high current output was there for this sensor. So you can think of milliamps as very high because usually it is uh, microamps or nanoamps, this kind of sensor. So for glucose concentration variation in the 1 to 3 millimolar range. So you can see it's a very effective sensor. So this got a patent granted sometime back, I believe 4 or 5 years back. This got granted. This is another interesting patent that we got. This is the area of predicting instabilities in uh, aero turbines and so on. You know, there the flame turbine, flame instability is a serious issue. So they had developed a process for measuring certain parameters of the flame and then identifying when the flame is going to go into instability, and so that they can correct the operating parameters of the flame or the engine to bring it back into the into so, so patents actually are very important for valuation. But technology is not only about uh, patents. A lot of other things have to happen. If you take a complicated product like something that has to go into the body, like a medical device, it will require a lot of studies, prototype and bench studies, animal studies, human studies. It has to be shown to be safe and effective. So both have to be there so that there's enough incentive to put those things. Uh, Devices like stents and pacemakers, they have to go through this kind of very stringent evaluation techniques. So there's a lot of expense involved in the development cycle itself. So only at the end of it you get the value, and any product that has to reach the market has to go through this kind of similar, value jumps and so on. Definitely, if you don't uh, see the identical steps, there will definitely be 2, 3 steps at least: demonstration and field trials and so on, pilot plant scale and actual scale has to be demonstrated. So finally, I would like to end the presentation by showing some uh, why statistics about how China has patented, uh, especially in the previous decade, I would say, uh, the till 2020, they were a huge power source, filing more patents than the other top four offices combined. And the reason they are doing it is because they want to crowd out everybody else. They want to remove the competition. So it's all about technology war. So if we want to propagate our technology, we need to develop products here. Develop, an Indian developed cell phone would be an ideal. Instead of buying an Apple, create something like an Apple phone uh, that's almost as good as as that. That's a very stretch goal, very much of a stretch goal. But that should be our. In some areas, maybe it has already being achieved. For instance, 5G technology. It's a lot about software, how the package redundancy is being deconvoluted and error rectified, and the package is reconstructed. When you do fast transmission, you should be able to do that. Then only you can ensure your speed of transmission. And the innovation is really only about the software. So you may already be aware of it. So I'll stop here and I'll let the Professor first. You can, if there are any questions, you can let me know. If you have the answer, happy to answer.
Well, thank you, sir, for your very informative presentation. Now, it is time for interactions. If anyone having any doubts, any questions, any queries, you can raise directly here, and Dr. Shankar is here for discussion. Any participants having any doubts or any questions?
Hello, sir.
Welcome, sir. Please.
This is Dr. Dilshad Khan.
Okay.
Actually, I have one query related to patent publication.
Okay.
Sir, actually, I have observed that sometimes what happens that the patent which we have filed take almost 1 year in publication, and sometimes what happens that the publication is published in 1 month only. Means there is the difference. Sometimes what happens that when we are when we are filing the patent, it took about 1 year, and the patent which is filed after the previous patent that is published earlier. So what could be the reason behind this?
Okay. Yeah, actually, the patent office could be has to mandatorily keep any patent application secret for 1.5 years, unless the inventor asks the patent to be published early. A fee has to be paid to get it published earlier. Additional fee has to be paid to get the patent published earlier. So in that case, a request for early publication might have been given.
But sir, actually, the thing is that I filed 2 patents by the normal process by paying the same fees. But one patent was published in 1 month, but the other, which was filed before this, was has not been published till now. Means that has taken 1 year almost.
When was this filed?
Um, uh, which is not published till now. That was filed about 1 year before.
Okay, you can actually check with the patent office.
Yeah,
You
I
can.
mailed to the patent authorities, but they are very lazy to reply.
Yeah. Unfortunately, they do not respond
Even,
very well,
even
especially.
I dropped many reminders, but they are not they are reluctant to reply
Mm,
regarding this.
yeah, I fully sympathize with you, especially Delhi patent office. I don't have that good an experience. Uh, mm, but there's no other way. Maybe you can make a personal visit if you are in Delhi. You just make a personal visit and you can check with them. Usually in person, they are a little more forthcoming with exact reasons. They may even advise you, okay, you do this and may get rectified. Sometimes when there's some technical requirement is there, which is not satisfied, it may not get published. But rarely such a thing happens these days because it's all automated process. Earlier, it used to be a manual process, this publication and all. Now, it has been streamlined enormously. The past, I have seen when I initially started in patent practice, it was all paper. Then it became completely electronic. And now the handling of processes within the patent office is also completely electronic. And in this, there may be some, I'm not sure what the pitch could be here. I think if you talk to the authorities, they may help you.
Thank you, sir. Thank you.
Any other queries from the participant?
So I will ask one question, sir. How many patents as NIT Hamirpur have you filed? I'm sure you would have filed patents. This year, how many were filed?
Uh, as Dean RNC told, I think this year 5 or 6. In the last year, I think already last year it was 11.
Okay.
This year, I think 5 or 6 that Dean RNC that time mentioned. Probably
Okay.
told that it is 5 or 6 already been filed, and some of them all. And last year it was 11. That was.
I hope some of the pointers I have given here will be useful for the faculty also to review whether the service providers are doing their job. Because you need to be very careful. Otherwise, uh, they may not do a good job. So there's a real risk that.
Yes. Okay. Yes, sir. Actually, I have one or two doubts. Like what you told, I just want to clarify. Like you told that the things which cannot be patented, like something which is does not have any relevance, or that question is basically
Non-useful.
not
Non-useful
useful.
in
Yes,
it.
yes, yes, not useful. So does that mean is it means that it does not have any practical applications or industrial applications like that?
Actually, the perpetual motion machine was given as an example. Within brackets, I have given perpetual motion machine.
Okay.
Perpetual motion machine is something you don't have to give any input. You simply keep on moving. Such a
Okay.
machine does not exist because it would violate the second law of thermodynamics, right?
Okay.
So no machine can work without any input of energy. So that's what we mean by non-useful. Actually, it's not that not to be literally taken. Actually, they of course there's also a separate category of abstract idea, not practically useful. That means not practically useful. That means you cannot sell any product or service with it. If you can even you can establish a website, and if the website provides a useful service, for instance, I'm using a program that I've subscribed to a program that creates PDF documents. Allows somebody to edit PDF documents. So that is a useful service, right? That's a useful product and a service. So they may have a software product, and they may be providing that service. So method and product also can be patented. Whereas a mere software that does an intermediate step, that will be difficult to patent. So only finally there should be something marketable in the product or service. So that's what we mean by usefulness sometimes.
Okay. And second query is like you told that it is better to publish the academic research articles after patent. So is it after filing or after the acceptance of that patent?
No, not acceptance. After filing.
Okay, after filing. Okay.
Yeah.
Okay.
You don't have to wait for the acceptance.
Okay. Well, any other queries from the participant? Well, if there is no queries, so then we will thank our speaker, Dr. V. Shankar, for accepting our invitation. Once again, I thank you, sir, for spending your valuable time with us, and hope that your informative session will get benefited by the participants. And definitely we'll look forward for your cooperation whenever we will organize such event in person physically. So we would like to you to visit our campus also. And probably this is one of the most beautiful campus in India, one of the beautiful campus. So you will mesmerize. So
Sure,
definitely we will in future we will definitely in touch with you whenever we'll organize such event in future under physical mode. So this time it is yes. So thank you once again, sir. Thank you.
Thank you.
Well, all the participants, so we will have another lecture, expert lecture. So it will be now we will start at 4:30. Okay, so we'll start at 4:30. In the meantime, Professor Harimohan Pillai has joined. Welcome, sir.
Thank you, sir. It's a pleasure to be here on this platform.
Okay, sir, we will start around 10 minutes.
Yeah, it is. 10 minutes later. Yeah, okay.
Yes. We will start around in 10 minutes.
Okay, sir. Thank you.
In the meantime, sir, actually, Professor Meenakshi Jain, actually, she was supposed to be here, but she was traveling in Jammu Kashmir, so I think that's why she was not able to join. And she told that say hello to you on her behalf.
Yes. I have been in touch with her for quite a long time. Yes.
Yes. She told, and the very first day when we are planning for this lecture, basically.
Yes. I am actually sitting in Vancouver in Canada.
Yes. You told that you are.
It's 4 in the morning.
Yes.
4 in the morning here. Yes. I hope I'm very glad that the connection is good, and I suppose you can hear me and see my video clearly. I was worried about that. If the connection is bad, then it becomes a problem.
So how was the weather there?
It's cold here. You can see me. I'm wearing something.
Okay.
It's about 12 degree, 14 degree, varies like that in the night.
Okay.
So, I'll try your first.
Well, we will start with our next lecture by Professor Harimohan Pillai. First, let me introduce him about Professor Pillai. Professor Pillai is a famous architect, academician, and author of several books. He is currently working as professor, design chair at MIT School of Architecture, MITADT University, Pune. He has completed Bachelor of Science in Chemistry from Maharajas College, Ernakulam, Cochin, followed by Bachelor of Architecture and PhD in Architecture from IIT Kharagpur. He has served various institutes as professor and so such as various institutes and departments such as professor and head of the department MES School of Architecture, Kuttipuram, Calicut University, visiting faculty at Department of Architecture and Regional Planning, IIT Kharagpur, reader and founder principal, Pillai's College of Architecture, New Panvel, Maharashtra, under University of Mumbai, visiting faculty, Bharati Vidyapith's College of Architecture, Navi Mumbai, lecturer and reader, Sir J. College of Architecture, Mumbai. Apart from this, he was a part of various review and selection committees, examination board across various institutes in India and worldwide. He is the author of several books such as Holidays, Science versus Pseudoscience, Technology and Me, Boy Babu, Flashback, Linkages in Architecture, Traditional to Modern, Naya Banda, and several others. So he has huge experience in both teaching, learning, as well as research and as an architect. He was also part of various architecture committees, various famous buildings. He was a part of various famous buildings also. So with this, I request Professor Pillai to take over and share your thoughts on how the design, the creative design is useful for commercialization of any products. So it is you to share.
Thank you, Professor Tapas. I hope I am audible and clear.
Yes, you are audible, sir.
The reason is, yes. Thank you, because I am sitting at a faraway place on the other side of the world, in fact. So I was a little worried about this. Thank you so much for inviting me for this session. I can see that there are more engineers and technologists, technocrats in this session. And in fact, I had inquired with Professor Tapas who would be my audience, because it is very rare that architects get an audience to talk about design and innovation. So I'm very happy that I am in the company of, in the august company of so many engineers and technology buffs, actually. What I am going to speak about is something very different. Architects are people who are very less understood by the society and even their clients also. So it's pretty difficult to convince people about what is creativity in design. I'll try my best to share my ideas with you. Let me begin by sharing my presentation. I hope I can share the presentation. Yeah. Um, is my screen visible, sir? Hello.
Yes, sir. Yes, it is visible.
Yes. So, friends, I am going to speak about creative design for innovation. And commercialization is something which I have put in parenthesis here, because I'm not too sure how much commercialization is possible for creative designs. It depends entirely upon the acceptance of the creative aspect of the design by the society. Not by other experts, but more by the society, because we architects design for people actually. We design for the comfort of people and we design for the comfort of the society in general. So unless a creative design is accepted by the society, it is pretty difficult to commercialize the whole idea as innovation. So I am going to speak about rather the whole process which we human beings have gone through in the past and continue to do so in the present, and we will continue to do so in the future also, about how to design creatively. I'm going to use several images to explain my thoughts on this. I'm calling it learning from the past, that we should, as designers, whether in the field of architecture or any other field of design, even in engineering design or technology design, we should continuously learn from the past experiences. And we should not actually completely disregard or forget about the achievements of the past. It is because design is a field which continues to churn ideas from the past. So in the field of art, I'll focus my attention on the field of architecture. What you see here are three images. Extreme left, you see an elevation and sectional elevation of a temple structure or a mandapam inside a temple in India. The second image is that of a journal published sometimes in 1919 by Bauhaus School of Architecture, which actually revolutionized the way we learn architecture or practice architecture or design buildings. The third image is a very contemporary image of a structure designed using digital tools. It's a shelter designed using digital tools. So I am going to talk about three different eras of design. The first one is how we designed till say 19th century. And the second one is what happened in the 19th and 20th century following the industrial revolution. And the third one is of contemporary times, when we have moved into another era of revolution created by digital tools and the advent of computers in our life. So if we compare these three ages, creative design was a process that used physical tools very skillfully in the past to create objects or artifacts for marketing purposes. I'm not very sure whether I should call it marketing purposes, but in case of design, in case of architecture, physical tools were very skillfully used to create objects, buildings, etc., for people to use or feel comfortable about conducting different activities. Whereas in the present world, creative design is a process that uses digital and physical tools. So in the last 50 or 60 years or so, this new era of digital technology has helped us create digital tools as well as physical tools in a very creative manner. But here we step back a bit and we create renders and presentations of objects for marketing purposes. So that's why we have developed websites for marketing purposes. We are able to connect to the rest of the world. If we create a tool, if we create something, we are able to connect to the entire world in an instance. For example, I am sitting here somewhere in the far away in different part of the world, and I'm connecting with you. So this has happened only in the last 30, 40 years, which is a revolution by itself. This ability to connect to every corner of the world through renders and presentations in the digital world. But if we compare the way people have designed in the East or in the Oriental world and in the Western world, there is a very interesting comparison which is possible. Because what I have noticed is that in the Oriental world or in the Eastern world, usefulness of objects appears to be more important than novelty. Whereas novelty seems equally important as usefulness in the Western world, if not more, because lot of novelties in creative design happen more from the Western world than from the Eastern world. So it is all about different ages of creativity, different tools which are used in the ancient times, in the recent past, and now in the contemporary times, and the kind of tools which will be used in the future also. So it is all about tools, skills of using the tools, and the creative products which human beings create. Once again, I have those three images above, and I have added three images below, which represent the tools of the different ages. In the past, if buildings were constructed, they were constructed by masons and carpenters using simple tools like chisel and hammer and hacksaw and whatnot. Whereas in the 19th and 20th century, following the Industrial Revolution, or maybe just a bit before Industrial Revolution started, the representation of design, instead of directly making the product, representing them in the form of drawings. The whole idea of drawings, orthographic projection, etc., developed in the 19th and 18th century. And the whole idea of design had to be represented on a piece of paper before it was executed. And this was a big change, a revolutionary change in the field of architectural design itself. Because architecture before 19th century was done on the site. There were hardly any drawings prepared, but it was all straight from the mind of the mason or a carpenter, that for thousands of years we have constructed buildings, temples, palaces, churches, cathedrals all over the world. But in 19th and 20th century, representation became the main tool. Actually, drawing became the main tool. And in the last 50 years or so, 50 to 60 years, this representation also saw a big change in the form of creating virtual representations, virtual drawings, virtual representation using digital tools, and which actually opened up a very, very, very innovative method of designing, because in virtual world, you could even simulate the design that you do. So we have three kinds of tools: simple, humble, chisel and hammer, then the simple and humble pencil as a tool, and finally today I would call it mouse, also a very humble tool, which of course all these three tools need to be handled by the human hands. That is the beauty of creativity. All creative ideas emerge with the use of human hands. So, but at the same time, marketing of these ideas, how do we do marketing of these ideas without communication and the logistics of transportation? If you look at ages of communication and logistics, that's also very, very, very important to be considered if you want to understand commercialization. Look at how we used to market things. Look at how we used to communicate things in just about 200, 300 years ago. The slowest means of transportation in India, as you can see, the bullock cart. And from there, the means of communication and transportation have seen a big change. Today, we are connected to the rest of the world using internet. We communicate. The era of logistics is here. Anything can be reached anywhere in as short time as possible. So this has also revolutionized the way we do marketing of a product. If today you have a wonderful idea, I'm sure with the communication and logistics platforms which are available today with us, in 24 hours it is possible to produce an object, a sample and share it with the rest of the world anywhere in the world. So this is the kind of revolution which technology has given us. So we have moved from hand to mouse to gestures in the field of creative design. It would take ages to create a wonderful piece of object or a sculpture or a piece of architecture in 300 years ago, but the time span gets reduced, and today even using mouse and in digital tools, and in fact another very interesting technology which is emerging is that of 3D printing technology. Even buildings are getting 3D printed without actual intervention of humans as construction personnel. So this is a very interesting age that we are living in, where we have examples of all these three types of creative efforts of human beings available all over the world. But who makes it possible? The question which I am going to address today here is, who makes it possible? ultimately it is the teacher of the tools and skills. I have been a teacher for almost 40-50 years, though I am also a practicing architect. I have also been in the academic world, and I have noticed that it is ultimately the teacher or the guru in any field which makes it possible through demonstration to the student about the different methods that we use to develop a creative idea. So 3 ages of skills by masters. I'm going to speak about different masters in the field of architecture who surpassed all the others in demonstrating the use of tools and systems. And we have had several followers to these masters in the field of architecture. Uh, let us take a look at the past. I'm showcasing you only the past in our country. I mean, if you look at the world, there is fantastic amount of architectural monuments to be looked at all over the world, built over several 100,000 years. Look at our own past. Were they meant for commercialization? All these buildings which we see in our countryside, built over several 100 years, they were rich with skills in our own languages. If you go to Tamil Nadu, we have fantastic example of structures created several 100 years ago by different dynasties and during different times, using different kind of evolving technologies. Same thing in Kerala or Maharashtra or any other part of our. But were they meant for commercialization? What is commercialization in the past? All these pieces of architectural marvel were actually made for made as useful spaces for the society. Were they meant for commercialization is a question. So they all come under the domain of traditional and vernacular systems of design. All that we have done in the past till industrial revolution comes under traditional and vernacular systems of design. They are also called the craft traditions of the world, which thrived all over the world in very different climatic contexts and which happened till the beginning of the 20th century. So whatever the human beings did in any part of the world, including our country, is called craft tradition, part of the craft tradition, which suddenly took a backseat because of industrial revolution in the beginning of 20th century. And how did it happen? The question is, how did it happen? For thousands of years, we were using our human hands for continuing with the craft traditions in different parts of the world. But suddenly there was a big change during the Industrial Revolution in the way we look at creation of objects, because we wanted to create multiple objects. We want to mass produce objects for mass consumption, which happened because of industrialization. The story actually rests in the history of what is known as basic design, a subject which is dealt with great interest in the field of architectural education. All the architects who are here, who are attending this, will understand it better. Basic design is a subject which is core to the learning of architectural design. And this subject was developed because of the skills of certain 20th century masters. So I will briefly touch upon this history of basic design. I do not know if there is this kind of history which exists in the history of science and technology in other disciplines, the story of basic design in other disciplines. But in many ways, what the 20th century masters in architectural design did also reflected in the way products are designed all over the world in the latter part of the 20th century and in the contemporary times. What happened was that in 1919, a school of design or architecture called Bauhaus developed in United Kingdom. And the history of basic design began with this school of Bauhaus. And in a very short span of 14 years, this method of design developed in that school of architecture, which led to the development of modern architecture, which the method of design and construction in modern architecture, which spread like wildfire all over the world based on what this Bauhaus school of architecture did in a matter of 14 years, in a short span of 14 years. They brought about this big revolution in design, creative design, and innovation. And one architect called Walter Gropius was the founder of Bauhaus. His is one very interesting statement is the ultimate aim of all creative activity is building or making. Creative activities happen in our mind, but the ultimate objective is to make an object. So on 12th of April 1919, look at this, it happened in 1919, just about 103 years ago. In just one century, there has been a big change in the way we design creatively and we produce objects and market the objects. This Bauhaus Manifesto was released in 1919, and it spoke about architectural design, sculpture, and painting, three disciplines of creativity. And in that school of Bauhaus school, they enrolled students, some 150 students enrolled, and more than half of them are women, which is very interesting because if you look at the history of design and innovation all over the world, before the 20th century or before even this 100 years ago, most of the creative design, execution, and construction, making of buildings, etc., were done more by men than by women. But with Industrial Revolution, with development of drawing as a tool for design, and later with digital revolution, it is more and more women who come into this field of design and construction of buildings. So these are the first 150 students who brought about this revolution in the field of design. And in place of traditional professors, teaching was done by masters to these students, masters in each field. Famous personalities, artists, sculptors, and architects joined this school to teach using their own practices as a method or a methodology for creating new generation of designers. And one among them, these masters, was one Mr. Johannes Itten. He was a painter and art theoretician. Look at this, a painter and an art theoretician was the father of basic design. And he believed in intuition and method or subjective experience and objective recognition. He developed a system for analyzing the process of design which goes on in the mind of a creative artist or designer or architect. And this method is still followed in all the schools of architecture all over the world today. Very quickly, I'll go through the process of Itten's teaching. Itten's classrooms were called studios, which even today, classrooms in all design institutions, especially in architecture institutions, are called studios. They are not called lecture halls or mere classrooms, but they are called studios. Because studio is a place for performance both by the teacher, the professor, as well as the student. Performance not as a stage performance, but performance of design as an activity. So in order to perform, you need all the materials and tools, etc., in the studio itself. So Itten's teaching comprised of creating objects, analyzing old masters, their works, making life-size drawings of objects created by old masters, and making use of different type of materials for creating models of those objects created by masters. He brought in materials into the studio to study, building materials and different types of materials, study of materials and natural objects into the studio to understand the quality of materials and the way materials need to be shaped to create a new object. Students were given several days to complete their task. It was not time-bound task. So this was another big revolution in the process of learning. Classrooms were not time-bound. You could work day and night. This still continues in the design studios in schools of architecture even today. They work day and night. The work goes on all the time, and students keep walking in and out of studios in different schools of architecture. And everyone was free to invent, work on ideas, and share their ideas with one another. So I'm showing you some of Teacher Itten's teachings, and these are all works done by students under his in his tutorial classes. The theory of form, understanding of elementary geometric shapes of circles, squares, triangle, and different types of polygons, which are core to the idea of design development, were the gift by Johannes Itten in the world of academics. This may look very, very simple to you today, but then it was Eaton's pedagogy which he developed to understand basic design principles and he introduced to the contemporary world. From two-dimensional drawings and paintings, he also moved it and taught his students the fundamentals of color and form theory, composition and design by making objects, which was again an entirely different method of understanding design, making models of objects. It was called a modern style of teaching, which was never experimented before by anyone. So you can see products of students, what students did in the way of trying to understand fundamentals of design. Eaton's teaching resulted in the birth of modernism in design. You see, we were talking about craft traditions which were prevalent for hundreds and thousands of years, I would say, before Industrial Revolution. But the birth of modernism happened in the field of creative design because of Johannes Eaton's teaching. And you can see very well see how modern objects were created, different kinds of objects were created. The course content of basic design, which was introduced as a subject in all schools of design and architecture, resulted in the modern era which followed in 20th century. And this method is even today followed in all schools of designs all over the world. But what about marketing? The idea of marketing happened because of industrialization, which was the process by which economy was transformed from a very primarily agricultural one to one that is based on manufacturing of goods. All of you are technocrats, you know what kind of big revolution happened because of industrialization. Individual manual labor was replaced by mechanized mass production. So the parallel activity of developing this simple system of understanding design through the world of basic design or the subject of basic design happened at the same time as industrialization, which was happening in the Western world. So individual manual labor was replaced by mechanized mass production and craftsmen were replaced by assembly lines because the whole idea of design was simplified using the subject of basic design. But at the same time, standardization became the gift of modernism because the idea of standardization evolved during the times of industrialization. The use of modules, assemblies, components, interfaces, methods or processes that are repeated through a project and from one project to other project. You all know it, all of you are technocrats and engineers, and this led to mass commercialization of objects. It's very interesting that if you look at the past of architectural design or any product design, every object which was produced was unique in nature till 200 years ago or 300 years ago. You see, you look at all the buildings all over the world in different cultures, no two buildings looked alike, which were created by architects. No two products looked alike. All products, all buildings looked different, felt different. But that is not the case with commercialization and industrial production, which is the gift of modernism. There's a very interesting statement. This is what we create by way of standardization as a gift of modernism, which actually destroyed craft skills in architecture and in the field of design all over the world. This is modernization where just pure repetition from one element to the other element all over the world, which we practice today because of industrialization and mass production. So what happened to creativity? It's a very interesting question. So here is a statement which I would like to read out by an architect, Sophia Bannert. It is about architectural profession, but it can also be compared with any other creative professions. What she says is the rigidity of the architectural profession constraining innovation? Are we innovative enough? Are we as innovative as ancient designers? So her statement is very interesting. She says, when I started designing a door handle in my last practice, I was told not to bother because the firm had a standard door handle design that they used in all their projects. I soon discovered it was not just door handles that were standardized, but standards included elements such as materials and junctions between them, lighting concepts, entire layouts of bathrooms, kitchen details, let us say. Everything from micro to macro had been standardized. Today, everything is standardized. So it became apparent that my job was to mechanically arrange the standard details into a new arrangement, as if picking elements from a prefabricated home catalog and put them together. So today, everything has become like using Lego blocks for design, for at least as far as architectural design is concerned. So it is, in many ways, this kind of standardization has constrained innovation, which is a very interesting observation by architect Sophia Bannert. But at the same time, let us not forget there have been several creative designers and teachers in the history of architecture, even in the modern times. These are some of those great architects who, in spite of the kind of standardization which was happening all around them, practiced what they preached and created design with a lot of innovation. Architect Louis Kahn, who designed the Indian Institute of Management in Ahmedabad and the Parliament House in Dhaka, though American architect who contributed a lot in our context in India. And then, of course, architect Frank Lloyd Wright, Corbusier himself, who designed the city of Chandigarh. They were all very creative designers with very innovative ideas who worked in different parts of the world. And in our own country, there are some architects who never believed in commercialization, who continue to work like those ancient architects, hands-on using materials. Two of them I remember is, one is Nari Gandhi, who came from United States after working under architect Frank Lloyd Wright, but set up his practice in India, whose projects you see here. And the other is Mr. Laurie Baker, architect from United Kingdom, who settled in Kerala, who was also a great teacher to architects through the process of apprenticeship rather than practice using modern methods. Apprenticeship, working under the architect, learning hands-on working under a guru, and creating new designs. And then came the revolution called digital revolution. And you have, I'm just showing you two masters of the world in the world of digital revolution. One was architect Zaha Hadid, the other is architect Norman Foster. And following them, there have been many more digital masters in the world today practicing, who have been doing innovative works in the field of design. We have one in our country who runs a company called Wall Makers, architect Vinod Daniel, who combines both the digital world as well as the manual world of design and visualization to create very interesting pieces of architecture. So what we learned from this, I would not say commercial architects, but the architects who continue to dabble in creative efforts, is the design and build type of practice, not design and draw type of practice. I'm coming back to the whole idea of studio, which has become now a workshop among these creative architects. Theory, working in the studio, and workshop as an activity is conducted by demonstrating skills by these teacher architects, these few architects who practice all over the world, who still believe in hands-on practice, but at the same time they use digital tools to enhance the effect of their hands-on practice. And the digital tools which have come up, which have evolved in the last 20 years, are of great help today. We have the tool called BIM, or Building Information Modeling, which brings together all the technology supporters in the field of design. I don't have to tell you what BIM is all about to all the technocrats who are present here. Building Information Modeling brings together architects, visual designers, structural engineers, services designers, electrical engineers, everyone together to work together in the virtual world to develop architectural designs by screen sharing in real time. This is all there today. So we are using the best of both the worlds by sharing a BIM model and working together in the field of design, structure, services, setting the construction sequence, creating the bill of quantities, and in fact, even animation of the built form and simulation of what all could happen to the building and under different conditions of climate and in case of any kind of disaster that could happen to the built form. So design, build, test, learn. This is a kind of cycle through which architects go on today. It's a lifelong quest for architects today or creative designers today. There was a time in ancient times when design and build was the only activity which designers indulged in. But today, testing, simulation, testing, learning, and again, improvising the design build methodology has become part of our professional practice. So from architecture, which was once upon a time called mother of all arts, the definition of architecture and creative design has changed from mother of all arts to science and technology of aesthetics and design. Architecture has become a venue or a science and technology of aesthetics and design, because the primary objective of design in architecture is today to provide physical comfort to human beings, with the aesthetics as creative value addition. Imagining architecture involves today, along with creative aesthetics, a structured, scientific, and mathematical approach towards skillful execution of the built form. This has now become perhaps being practiced as architecture today, and it is also a demonstrative art. But at this, we are actually on the cusp of another revolution. I may not live to see this, but I am already seeing this revolution happening. The new generation architects are in for a big change. They are on a cusp of another revolution where artificial intelligence enters into the world of design. It has just started. From human to robotics to artificial intelligence to humanoid forms, design will become, I'm sure design will become a part of computer programming. You will create designs by simply writing a program, and these days are not very far in future, because already these kinds of ideas are being explored to colonize other planets, which is happening, which will happen very soon. So we are on a cusp of another revolution. The role of architects and designers are going to, architects and designers will play a big role, and for that, computer programming and keeping pace with other technocrats will become an essential aspect of architectural education as well as practice. So change is just ahead. I know that. So let us all be part of the change and participate in the change that is going to happen in our world in future. Thank you very much. I hope I am able to connect with all of you with my ideas as a designer architect, and also a teacher for several years. Professor Tapas.
Thank you, sir. Thank you for your wonderful portrait of things. Actually, it was quite interesting presentation, I must say. Now,
as an architect, though we work with many engineers, it becomes sometimes very difficult to convey what we have in our mind by incorporating all that contribution of technocrats. So I was just using images to explain the thoughts that I have. But I would like to just quote another senior architect friend of mine, Dr. Shashikala Anand, who practices from Chennai, who is a great follower of traditional systems of design. Even I am also a great follower of traditional systems of design, and my PhD work was on traditional systems of design in our country. So you see, there are three statements which are very interesting in our traditional systems of design. These are three Sanskrit words which I would like to leave with all you technocrats who are here. It's called design should be bhogadyam. Bhogadyam means functional. We all know it. A design should be functional in nature. But this was known to our ancients. You see, it is nothing new actually. Design should be bhogadyam, sukha darshanam. Means design should be good to look at. Of course, that was something which was followed very strictly by ancient designers. That design should be not only bhogadyam, but sukha darshanam. But the third aspects of design which ancients talk about does not exist today. It is called ramyam. Design should be ramyam. Ramyam means one should feel devoted to the design that you have created. I mean, it should be worth worshipping. But today we don't worship designs, we commercialize design.
Yes.
You see, all the craftspeople of the ancient times, even all those hands-on craftspeople, they worship their work. They worship what they do. So that idea of ramyam exists in the products created by human hands in the past, even today. But the idea of ramyam doesn't exist in commercialized products. I'm pretty sure of that. So in many ways, we have to go back to our hands because these are the finest tools which nature has created. No amount of tool creation by human beings can surpass the value of human hands because they directly connect to our brain. No other tool can connect to our brain as well as human hands. Thank you.
Well, thank you, sir. Any questions or any queries from the participants?
In fact, I have a question or I have a thought. I was listening very intently to Professor Shankar who spoke before me.
Yes.
He was talking about patenting,
Yes.
and I was wondering, have you heard of any architect trying to patent his designs? I have never heard of architects trying to patent anything. I don't know. So far, I have not heard of. I don't know if in contemporary times any architect is filing a patent. I'm not very sure. But I would like to hear from you if you have heard of any architect who has, or a designer, architect, especially architect, who have tried to patent something. But architects seem to create every building they want to create in a different way. New ideas. But have you heard of any architect who has tried to patent something? I have not heard. I would love to meet an architect. All these architects masters I have showed you, they have never tried to patent their ideas. They share their ideas with the rest of the world to learn and to create new things. So
actually, as per Dr. Shankar's lecture, it was seen that there is something that some design can be protected, basically.
Protected, yes.
So, like you are talking about some building, suppose new design of a building. So that type of that can be protected under IPR itself. But I am not also sure about the patenting of that type of design.
Even I am also looking for, because from ideas point of view, you can put several ideas for patenting, correct? But I don't know. I have not heard of architects trying to patent their buildings or design ideas. They move from one design idea to another design idea, and that's it. That's the way it is.
Actually, sir, my general, just I am from engineering background, so I don't have much idea about this. So now, when you think about a new design, let's say whether it is building,
yes.
So what are the basic things basically people should think?
You see, that's a very good question. I think it's a good idea to share. You see, when we think of a design, there is a kind of visualization process which goes on in the mind, correct? So in that process of visualization, there are two types of ideas which come together. One is how to handle tangible objects and how to handle intangibleness in the design. So there are two things which have to work together to produce a good architectural design. There are two aspects of design. The tangibles are the building materials, the structure, use of brick and material, etc. Those are tangible things, correct? Intangible is how the wind flows through the building. How ventilation happens in a building is an intangible thing. Or how sunshine will come from different direction, how warm the room will be, how cold the room will be, which room will be good in summer, which room will be good in winter. You see, those are intangible things which cannot be measured with any kind of tools or equipments, but it can be understood. Again, I would refer to our ancient designers and architects who relied a lot on their indriyas, panchendriyas, that is feelings. So intangibles can only be measured or understood by panchendriyas, your indris, which indris cannot be replicated by any technology, that I am very sure of. Whatever may be the technological revolution happens in this world, indris cannot be replicated. So intangibles are understood by a designer through panchendriya. So when you visualize a building, you sit on, many of these great masters would sit on a construction, on a property and sketch the building. And finally the building will be constructed the way the master sketches it. Because two ideas are going on in the mind, the intangible and the tangible. How the tangible will be created so that the intangibles can be managed in a very efficient manner to create comfort conditions in different parts of the building. That's the kind of thoughts which go on in a designer's mind. So a good design can happen only if an architect sits on a construction site or a site where you want to design, because every tree matters, the directions matter, the cardinal directions matter, the sunrise matter, the sunset matters, wind flow matters, rains matter. So usually a good design gets evolved only by experiencing the site for over one full year of climatic change, and which has to be experienced. It cannot be recorded and studied using, any kind of recording devices. So that is a combination of tangible and intangible, which goes on in the mind of an architect. So I really wonder whether artificial intelligence will be able to replicate this tangible and intangible in future.
Yes. Yeah. Well, any other queries? Well, I hope that there is no other queries right now. So if if there is no such queries, then let's thank our speaker once again. So we thank you, sir, for your presentation, wonderful presentation, I must say, and accepting our invitation. Although you are traveling, so still you have accepted our invitation. So we are thankful for that, and hope that in future also you'll get cooperation from you, and we will like to invite you in person to visit NIT Hamirpur.
Yes, sir. Thank you so much. Thank you for this opportunity, and of course I will be in touch with Madam.
Yes. Actually, Madam was there, but I think she got disconnected. Right? It's just she was little bit. For some time she was there, but now she got disconnected. So
thank you.
You are welcome always. Anytime you are coming to Himachal, please visit NIT Hamirpur.
Yeah, sure, sir. Thank you. Namaste.
Okay. Thank you all. That is the end of our today's session, and our next session will be on 11th of July. So all the participants are requested to make a note that the next session will be on 11th of July. So I have already shared the schedule with all of you, and I will share a feedback form. There is also a Google spreadsheet. So maybe in a day or two. So kindly fill that Google Sheet form. So that is kind of a feedback for the session 1. So with this, thank you all for joining us today. Thank you all.
Thank you, sir.
Thank you, sir.